Hello, dear students. Welcome back to one more session on the public international law. In today's class, we will be discussing about the state succession to treaty and contractual rights and obligations. So, we'll be studying both treaty rights and obligations as well as contractual rights and obligations. In this regard, how and when there is going to be state succession, that means when these rights and obligations arising out of treaty or arising out of contracts will pass on from the predecessor state to the successor state. That's what we'll be discussing in today's class. And before proceeding further, let us try to recollect what we discussed in the previous class. In the previous class, we had a discussion on the theories of state succession. We almost studied and discussed 9 theories, and we realized that there is so much of divergence of opinion among different jurists as to the basis of state succession and what rights and obligations can be subject matter of succession, what cannot be a subject matter of such succession, what shall be the attitude of most of the states, what are the principles governing such a succession of rights and obligations. In this regard, there is so much of differences of opinion, and this has been considered as one of the areas in public international law which has been highly politicized, and there is no uniformity in the practice. So that is what we understood in the last class. Keeping this in mind and in this light, let us try to understand specifically as to what are the governing principles as far as succession to treaty rights and obligations whenever there is going to be a change in the sovereignty of a state in a territory, and what shall be the principles governing succession to the rights and obligations arising out of contract. That is what we will be discussing in today's session. And with this, let us start this with the one important fact which tells that there is no general rule as to succession to treaty rights and obligation. That is the starting point. What we find at the international level, even today, we don't have a general rule that all treaty rights and obligations pass from predecessor state to successor state. There is no such rule. There is no such obligation on the part of the successor state that it should accept all the rights and obligations of its predecessor regime. So that is the general rule. And further, we, as I told just now, in this regard, as to what can be the subject matter of succession about treaty rights and obligations, no uniformity in the state practices. States, they just do whatever they feel proper and whatever they feel comfortable or convenient for their own personal interest. So in this regard, there is no hard and fast rule accepted by most of the states. So they follow their own convenience. And further, even among jurists, as we found in those 9 different theories, each one gives his own reasons and his own justifications for their divergent opinions and principles. That's how it is as of now, as far as this concept of state succession to treaty rights and obligations are concerned. There is no uniformity in practice, and there is a lot of difference of opinion among jurists as to when and where and how rights and obligations of the predecessor state will pass on to the successor state whenever they are the result of a treaty. That is the position. And in spite of this, there have been endeavors, there have been attempts made at the international level to codify the law dealing with this succession to treaty rights and obligation by the new regime. And one of the important effort in this regard which we can find is that of Vienna Convention on Succession of State in respect of treaties of 1978. This is one important effort or one important uh, what is this development which has taken place at the international level, whereby international community tried to codify the law, international law, with respect to succession to treaty rights and obligations. If you go through this convention, one thing which we can conclude is that most of these rules which we find, articles which we find in these conventions, they are more like a description than prescription. That means they are not prescribing that these are the obligations which you need to follow. They are saying that if at all there is a case of state succession, these are the possible ways or possible methods you can follow whereby treaty rights and obligations can be dealt. It is more of a description than prescription. So that is the fate of Vienna Convention on Succession of State in respect of treaty rights and obligation of 1978. So this is a brief introduction. In spite of this being a merely a descriptive provision, if you just look into those some of the important key features or key principles laid down in this Vienna Convention, that is going to be a guidelines, that is going to indicate or it gives a direction to the new states which will be coming up by succeeding to the extinct state or its a predecessor. What shall be done by them, how they will be behaving, how they will be involving their practices with respect to rights and obligations which are the result of a treaty to which its predecessor was a party. Are they bound by it? When they are bound by it, when they are not bound by it? In this regard, few explanations are tried to be understood, or few principles are to be understood in the coming discussion. So that is with respect to introduction to the succession to treaty rights and obligations from predecessor state to the successor state. Moving further is a general rule in this regard and exception. There is a general rule under the Vienna Convention that executory rights and obligations of a predecessor state does not pass to the successor state. Look at those terms which are being used. Executory rights and obligations. You studied in your law of contracts the concept of executed contracts and executory contracts. Executed contract means whatever needs to be performed under the contract has been performed, then that is executed. Executory means it may be partly performed or not at all being performed by both the parties. A contract has been made, that's all. Neither of the parties or any of the parties are yet to perform their part of the contract. This executory. So as far as this general rule is concerned, it says that whenever the rights and obligations arising out of a treaty is executory in nature, that means the parties to the contract, they are yet to perform their part which needs to be performed in the future. So then such executory rights and obligations of the predecessor state will not pass to the successor state. They won't. The rights and obligations, they won't pass from predecessor state to successor state, but only this is a general rule. As I said in the beginning, so this is only a general rule under Vienna Convention. It has many exceptions. What are those exceptions? These exceptions to these general rules can be grouped under three heads. Exception 1, 2, 3. We will be discussing each one of those exceptions in detail hereafterwards. First exception is concerned with treaties which are directly related to the territory. We had a discussion in the last class when we were talking about the theories of state succession. One of the theories says that there are dual personalities for the state. State has two personalities. One is the political personality and the other is the social personality. So based on that theoretical concept, now we have a exception to this general rule that there is no succession to treaty rights and obligation. It says that whenever treaty rights and obligations is something which is directly connected with or related to the territory, then it is coming under the concept called social personality of a state. What is changed? The political personality has been changed, but social personality remains intact. So whenever territorial treaties connected with the territories, directly connected with the territories, this is not going to be affected by change in the regime. So merely because there is succession of state, a new state has come in the place of the predecessor state which extincted, that is not going to affect the treaties which are directly related with the territory. Some of the illustrations for such treaties are treaties connected with boundary regime and servitude. So whenever a treaty has been made because of based on which boundaries are fixed, thereby they say that beyond this you cannot proceed or you will not exercise any jurisdiction beyond that. That is something which is binding or which is going to be accepted. It has to be accepted even with the predecessor state, successor state, excuse me. Successor state is also bound by the boundary regimes fixed through a treaty to which its predecessor state is a party. Similarly, servitudes, giving right of passage, right of sharing the waters of the international rivers. Servitudes, these are all. So they are going to continue from the predecessor states to successors. They have agreed that this much of water is going to be shared. A treaty has been made with the predecessor state. New state comes into existence. They are generally even bound by those treaties connected with the servitudes and boundary regimes. One more example in this regard is that of neutralizing and demilitarizing. We already studied under the chapter state in general the concept of a neutralized state and demilitarized state. The most famous example of a neutralized state is that of Switzerland. Let us take an example. Today, Switzerland is a neutralized state. What is the basis for it? It is based on a treaty which Switzerland entered into with all major powers in Europe. Every state is interested in Switzerland, and but because of this neutralization, no state is going to attack Switzerland. At the same time, Switzerland is also not going to take the side of any state if there is a conflict. That is what is called as the concept of neutrality. So it is an outcome of what? It is an outcome of a treaty. So let us assume that tomorrow Switzerland as a state as such has lost its existence and a new state has come into power in Switzerland, because ultimately Switzerland is a territory to which there has been a change in the regime. So new regime is in general bound by the previous treaty of the predecessor state of Switzerland regarding its neutrality. So that obligations and rights arising out of the treaty of neutrality, it continues to the new regime which may now rule the Switzerland. Similarly is the case with demilitarization. So whatever the treaty is made under which the nation has been demilitarized with the agreement with different treaties with different countries, the rights and obligations arising out of such treaty, they will be they will be passing on from the predecessor state to successor state. That's how it works. Moving further is the second exception. It is concerned with such multilateral conventions which are going to be common to every state, irrespective of the person who is governing, irrespective of the people who are in power. Once you are once you are a state and once you are a member of international community, this such conventions are bound to apply to you. You cannot say that I am secluded from that, I am separate from this. Such treaty obligations, they will the rights and obligations arising out of such treaty obligations, they will continue, they will pass on from the predecessor state to the successor state. The examples are treaties connected with health, treaties connected with the narcotics, and treaties connected with human rights. In this regard, these are the conventions which are going to be of universal application, and they are nowhere connected with the political setup or the political administration or the people who are in power. So that continues even to the predecessor state. Predecessor state cannot say that I am not bound by this international covenant on economic, social, and cultural rights, whereas it was or its predecessor was a party to it. You are bound by it. So that's how it works. So that is the next second exception is multilateral conventions dealing with health, narcotics, and human rights. Even though they are executory in nature, they will continue. Moving further is the third one. Third exception is reasonableness and equity. We know that whenever a rule, if it is strictly applied, it is going to create problem, it is going to cause injustice, it is going to be unreasonable. To remove the rigors of this strict application of an rule international rule, then it still you have to ensure that such injustice should not be caused. Therefore, what is going to happen? Equity will be used to mend, it is going to be used to temper or to reduce the rigor of this principle. One such instance is, that is example which we can give is that of consideration had been executed in favor of the existing state, its benefit is being reaped by the successor state. Then still in such situation, the successor state is continues to be held responsible by the rights and obligations arising out of such treaty, of which the benefit has already been received by the predecessor state, and its benefit is continued to be enjoyed by even by the successor state. So it continues to be there. Moving further, successor state in such situation is held liable. So these are the three exceptions to the general rule regarding regarding not passing off the rights and obligations from predecessor to successor whenever the nature of the rights and obligations are executory as such. That's with respect to the general rule as and its exceptions. Next comes cases of no succession. There are few instances, there are few treaties and rights and obligations arising out of few treaties. They will not pass on from the predecessor state to successor state. Example is that of political treaties like extradition and commerce. They come to an end along with the state. The state which has entered into such treaties of extradition or that of commerce, they will come to an end along with the state. Next comes multilateral conventions in which entry of new state is restricted. There are going to be many conventions where a new member can a new member can be admitted only with the consent or consensus of every other member. In such situation, a new state which has come into existence by the extinction of its predecessor state, it won't automatically become the member of that convention. Therefore, it won't get those rights nor having those obligations of that convention. There are a few more kinds of conventions or treaties where the admission of a new state is based on an international organization's decision. International organization procedure is going to be laid down, and based by for complying with the procedure, a formal declaration or decision has to be taken by the international organization saying that this particular new state has to be admitted to this convention. Then they have to follow that. Otherwise, there is no succession to treaty rights and obligations. So these are the cases of no succession by operation of law of rights and obligations from predecessor state to successor state. That's how it works. Moving further is the practices of state. As I said, there is divergence of practices among states. Especially, we can find such divergence after this decolonization, where a number of new states have emerged from in Africa as well as in Asia. Their practice as to the succession to treaty rights and obligations from the previous regime to the new regime, there is absolutely no uniformity. There is difference of practices among different states, and they most common methods they follow is entering into a devolution agreement. Whatever is the previous regime, with them they will be entering into an agreement by the new regime. Thereby they decide what has to be uh, what are the rights and obligations which are going to be succeeded. Similarly, inheritance agreements, even that is going to tell, and the basis of the agreement what needs to be the subject matter of succession, what is not going to be the subject matter of succession. They can decide it among themselves. Going further is the unilateral declaration. Nothing is done, we will make a declarations. We as a new state, we emerged after decolonization or de-sovietization. As we discussed, after the US end of USSR, we call it as de-sovietization, and before that decolonization. These new states, they may choose that we will unilaterally declare that what are the rights which we accept, what are the obligations we accept, what are the rights and obligations which we reject. What is the tool they use? As we discussed in the last class, is that of clean slate principle and pick and choose principle. These are the two important theories. They say that look, ultimately it is our state, ours is a new state, it's a clean slate, it's a new personality, and we have no link whatsoever with the earliest regime. So we will decide what to be accepted, what to be rejected. Pick and choose. That those are the tools which are used by most of the new states after decolonization as well as de-sovietization to decide what rights and obligations can be the subject matter of succession from predecessor state to the successor state. This is the state practices regarding succession to treaty rights and obligations. Okay, moving further is the treaty succession to contractual rights and obligations. So far we discussed about succession to treaty rights and obligations. Now we will be studying about succession to contractual rights and obligations. Many a times in your examination, questions are going to be asked like this only. Explain the effect of state succession on treaty rights and obligation. One. Second one, treaty on rights and contractual rights and obligations. So you have to explain both. So treaties are going to happen among the nations. different nations are going to enter a treaty. The treaties can be bilateral, treaties can be multilateral. So that is what has been dealt so far. Moving further now is the succession to contractual obligations. How it works, let us discuss the same. So in this regard, the position earlier, as we can understand, with the help of a judgment given by the English Court of Appeal, sounds to be very strange and astonishing, and it creates a great difficulties for nations. So what is that case is? The case is about Western Central Gold Mining versus Mining Company versus R. This was the judgment given by the English Court of Appeal. This was the position of law as far as England was concerned in those days, or the practice of the state of England in those days. Let us see what the judgment was. It says that if there is extinction of a predecessor state by conquest or annexation, one new territory has been annexed or new territory has been conquered by a state, then successor state is entirely free to decide whether or not to be subrogated to the rights and obligations of the previous regime. They don't want to be put into the shoes of the previous regime. We are free to decide what stand we have to take, what has to be accepted, what has not to be accepted, and to what? To the contractual right and duties of its predecessor. We are not bound by them. We will decide once a new regime to which territory has annexed or the new territory which has been conquered by a state. The successor state will decide whether to accept or not to accept the contractual rights and obligations of the previous regime. This created a big problem. This used to create a big problem for everyone. Therefore, they wanted to mend or they wanted to temper the stringency or the what we say the harshness of this rule. Therefore, the current position what we have today is evolved. What is that current position? We'll be studying here afterwards. So the position is that need to temper the stringency of this rule led to the current position. What is the current position? Let us try to understand the same. So the current position is this. So emergence of the doctrine of vested and acquired rights, and the lines and the principles which are on the similar lines as we discussed in the previous topic, that is succession to treaty rights and obligations. Here also the concept of vested and acquired rights and the doctrine of vested and acquired rights were being used to mend or to what we say to temper the stringency of the law which was prevailing in those days regarding succession to contractual rights and obligations. Let us see what this is all about. So salient features of this doctrine is this: no succession to the claims in the nature of unliquidated damages. I hope all of you studied the concept of unliquidated damages, which is one of the fundamental feature of law of torts. In law of torts, the remedy is unliquidated damages. Unliquidated means something which is not be clearly quantified from the beginning or beforehand. That is what is unliquidated. So whenever there is going to be rights and obligations which cannot be clearly quantified under a contract, so then in torts they can be called unliquidated as well as liquidated damages in case of contract, whereas in case of torts the remedy is always going to be unliquidated damages. So that being the case, no succession to the claims from a contractual rights and obligations whenever the nature of claims are going to be in the form of unliquidated damages. No succession as far as such claims are concerned. Moving further, if elements of quasi contract is involved, generally no succession. But if elements of quasi contracts are involved, then and benefits of such contractual obligations have already been vested in the predecessor state or have been used even by the successor state, then successor state will be held liable for such quasi contractual liabilities to which the predecessor state is involved. I hope you know the principle behind the very concept of quasi contract is to prevent unjust enrichment. No one should be enriched at the cost of someone else unreasonably. Similarly, if at all the predecessor state has entered into a contract with some other state and the predecessor state has received the benefit out of it, but it is yet to perform its part of the duty, then and before that could be performed, it has lost its existence and successor state has come. And then successor state is bound by such quasi-contractual obligations. It cannot say that I am not bound by it. No, it has to follow that. Then further, but it is also subject to an exception. Even if it is a contractual rights and obligations is in the nature of a quasi-contractual principles involved, still there is no question of succession to such rights and obligations whenever rights or obligations are not in conformity with the public and social order of the successor state. The successor state was established based on few fundamental ideologies, based on few fundamental principles, and these rights and obligations, even though they may be arising out of a quasi contract, even though such rights have already been vested in the predecessor state, if it is in conflict with the existing social order or existing public order of the successor state is generally not going to accept such rights and obligations. It is going to reject, even though it sounds to be at times unreasonable. But states, successor states, they will be giving more importance to their own public order and social order than the quasi-contractual obligations of its predecessor states. So these are few things which we should know as far as the succession to the rights and obligations arising out of contracts. Rights and obligations arising out of contract. There is no rule that there is going to be a succession, but in case of quasi-contractual interest involved, then there is going to be succession. Otherwise, those which are yet to be if the obligations are executory in nature, there won't be any succession. These are few important things which all of us must know as far as succession to contractual rights and obligations. So with this, we will finish our session for the day, and in the next class, we will have a very brief session on what we call the concept of kinds of state succession. A very few things to be discussed. We'll be discussing in a small video in these concepts in the next session. Okay, thanks to all of you.